following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the legal aspects surrounding Interpol. How does the international policing environment affect the means of justice in Sri Lanka? And what can we expect with involvement moving forward? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Today's topic is a very interesting one that we haven't been able to touch on this program so far, but hopefully we'll be able to get a lot of insight into it, especially considering just how global of a scale it is we're talking about, and that's on Interpol and its legal intricacies when it comes to handlings in Sri Lanka. To speak about this, we have one of the most well-suited individuals for this program, and that is Mr. Lakmal Ratnayake, attorney at law. So thank you very much for taking the time to come to our studios today and to try and explain this very vast topic to our audience. We really appreciate it. A bit of an introduction to Mr. Lakmal. He is an attorney at law with over 21 years of practice, specializing in criminal law, and he's also the former chairman of the NICD, JCT Limited, CWE, and if you'd note, he's also one of the former directors of Sri Lankan as well. So it's very safe to say that when it comes to the area of Interpol and just how international of a context we're talking about, we're in very good hands. So to get you a little bit of an understanding of how exactly we're going to move about with this program, we're going to get into the basics first. What is Interpol and its legal discretion? And next we'll be talking about the current context and especially how Sri Lanka plays into this role. And finally we'll be talking about what we can expect moving forward when it comes to this area.
Hello, my name is Salman and I'm a digital marketer. My question is on fundamentals. How does the framework for international police function in Sri Lanka?
All right, well, without any further ado, let's get right into the basics and foundations of this topic. Once again, so thank you very much. We have a lot to get through, but hopefully we'll be able to get enough context into each area as well. Before we get into the specifics about how Interpol functions in our context, I think it's important for our viewers to understand what exactly Interpol is. Can you please lead us in with an introduction on what Interpol really is essentially and its functions when it comes to a global scale?
Thank you for inviting me for this program, Anuradi. So getting back to the question, Interpol is the largest police organization in the world. So it is the international police. So Interpol, what it basically does is, it does coordination, facilitation for police cooperation all over the globe. So it is more of a coordinating job that they do than enforcement. Now, for example, in the movies, in Hollywood movies, you would see the Interpol agents being on the ground, doing raids and ground operations with wearing Interpol jackets. This never actually happens in real life because Interpol does more of a coordination and facilitation, and they coordinate between the NCBs of each country and they are not into enforcement. So this is how the Interpol operates. They have a communication system, Anuradi, called the I-24/7 communication system. So this is the communication system that they use to communicate with the member states. So the communication system operates from the head office, which is headquartered in France, and they have the regional officers backing up the head office. The regional officers are based in Singapore and also in South America in Argentina. So the coordination is done and the information is updated. So whenever a member state requests for information from another member state, they update this I-24/7 communication system for the required information. And if the required information is legit, the other member states will respond and they will update the system accordingly, giving the information that is required for the necessary cooperation and the coordination to be made. So it's a huge operation, it's a global operation, and of course there are certain limitations to this. Now the Interpol has its own set of rules, and the Interpol has its own constitution. So it is governed by the constitution and the Interpol set of rules. The Interpol set of rules are called the Interpol's rules on the processing of data, which they call the RPD. And the international Interpol has the constitution. So according to Article 3 of the constitution, Article 3 Anuradhi discusses about the limitations of the Interpol. So basically, Article 3, if I may be permitted to read, it is strictly forbidden for the organization to undertake any intervention or activities of a political, military, religious or racial character. So these are the limitations that are mentioned in Article 3. So in order to ascertain whether this, whether a crime would fall under this, the Interpol will look into these aspects when they conduct an investigation in order to prevent or control crime. In certain instances, there could be instances where a certain crime has two elements. It has a political element and also the criminal element. And then the Interpol would look into which element is more dominant, the dominant element. So in a situation like that, they would, if the dominant element is the criminal element, then they would make an exception, and they would still look into the matter if the dominant element is the criminal element. If the dominant element is the political element or the military element or the religious or racial element, they will not investigate into the matter. So this is how the Interpol operates. So the Interpol will also look into international crimes and cross-border transnational crimes. So international crimes would be, for example, crimes like genocide, crimes against humanity, war crimes, and similar offenses. And cross-border transnational crimes would be crimes like money laundering, drug trafficking, human smuggling. So for transnational crimes, mainly the NCBs of each country will investigate. For international crimes, of course, sometimes even the International Criminal Court will seek sometimes the assistance of the Interpol to look into those matters. And also, if I may talk about the NCB, each member state in the world has their own NCB. So there are about 196, exactly at present I think there are 196 members, and each country has their own NCB, which is called the National Central Bureau. So this National Central Bureau is the link, is the heart of the Interpol. This is what links the Interpol and the police department of the member state.
That's exactly where I wanted to lead to as well, sir, when moving into our context as well. Now that we've gotten a foundational understanding of how Interpol actually operates, and it's not just, you know, like you mentioned, according to common knowledge, an enforcement authority, it's actually quite the opposite. When it comes to Sri Lanka's context as well, sir, now the National Central Bureau that you mentioned, how exactly does it work in our context?
Yeah, now as I mentioned, the NCB is the heart or the link between the Interpol and the police department of the member state. So the NCB in Sri Lanka, of course, is based and headquartered in the CID premises, and the officers who work for the NCB are the CID officers, and they access the system, the communication system I mentioned earlier, that is the I-24/7 system. So whenever a member state requires some information with regard to a person living in Sri Lanka or something related to Sri Lanka, the NCB of that particular member state would make a request for that information through the system, communication system I mentioned as the I-24/7 system. So when such a request would be forwarded, the Sri Lankan NCB will look into that request and see whether it's a legit request, and if it's so, if they think that it is a fit and proper request to be processed, they will look into that matter and they will forward all the required details to the system, and that particular country will have enough information with regard to what they require. So this is how the entire network operates globally. All NCBs connect together and they operate through the I-24/7 system. If anyone is aggrieved or not satisfied with any action of any of these NCBs and the Interpol, there is a process that can be used to challenge this. That is mentioned in Article 36 of the Constitution, and that is the commission, which is an independent commission of the Interpol, which looks into these appeals and requests and representations that are made on people who are aggrieved by any of the actions of the Interpol. So Article 36 also, if I may read.
Yes, of course.
Article 36 states, the Commission for the Control of Files, it is mentioned as the Commission for the Control of Files, is an independent body which shall ensure that the processing of personal information by the organization is in compliance with the regulations the organization establishes in this matter. And it goes on, the Commission for the Control of Files shall provide the organization with advice about any project, operation, set of rules, or other matter involving the processing of personal information. The Commission for the Control of Files shall process requests concerning the information contained in the organization's files. So, anybody who's dissatisfied with a publication or with an action that has been taken by the Interpol can make a request and an appeal to this independent body for their grievance to be heard. So that will be done only through written representation. So once that written representation is sent, they will process that, and if they feel that there is a ground to be looked into, they will definitely look into that. And if the Commission comes to the conclusion that a person's rights have been violated, the Commission will take steps to inform and advise the Interpol to rectify that. So in situations like that, say if a red notice is published and if it has not been done with the correct compliance, then Interpol would take steps to rectify that situation, and in a situation like that they might even withdraw the red notice or take steps to amend or do the rectifications necessary in order to put matters right.
Right.
So
I want to talk about the red notice aspect as well, and also get into, you know, the qualifications of what an international crime is and all those specifics. But our time has run out on this specific segment, so let's take a very short commercial break. We'll be right back after this.
Hello, my name is Nathalie Dias and I'm a lecturer at ECU. My question is on nuances and the current context. but protection and enforcement are overseen by the bodies of Interpol across the globe.
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Lakmal Ratnayake, attorney at law. We're just getting into the basics of Interpol and the law surrounding that as well, and how Interpol functions specifically when it comes to Sri Lanka's context. So once again, so thank you for that previous segment. I believe we covered a lot of specifics when it comes to what Interpol is as an organization and how exactly it's going to function on a global scale. Now I'd like to move into what you just left us off on before we finished the break, which was on red notices. Can you please explain to us what exactly a red notice is? Is it just an arrest warrant, or is it more? Is it just an inquiry of information? How exactly does it differ from an international arrest warrant?
Well, Anuradhi, international arrest warrant is different from a red notice because the international arrest warrant is issued by a court of law and a judicial officer would issue an arrest warrant. But the red notice is a publication that will be published by the Interpol, and it will be published in the I-24/7 communication system so that all the member states will have information of that red notice. So red notice basically is a notice that is for the purpose of locating a criminal. If they don't have information as to where the criminal is residing or staying at present, for the purpose of locating the criminal, they will publish a red notice. And it will be published, and it will be for the purpose of locating, then for the purpose of arresting, detaining and restricting the criminal's movement for the purpose of extradition and surrender. A red notice will be published. So it is different from an international arrest warrant. So basically articles 82 and 83 of the Interpol's rules on the processing of data discusses about a red notice. So red notice, if I may read article 82.
Yes.
Purpose of red notices. Red notices are published at the request of a national central bureau or an international entity with powers of investigation and prosecution in criminal matters in order to seek the location of a wanted person and her detention, arrest or restriction of movement for the purpose of extradition, surrender or similar lawful action. So a NCB can request for a red notice, and also apart from a NCB, a National Central Bureau, an international entity. So I explained earlier what a NCB is. So NCB, all the member states have their own NCBs. So the member states can request for a red notice through the NCB or an international entity, like for example the ICC, the International Criminal Court, can request for a red notice. So there are certain preconditions. So a red notice is issued mainly for the purpose of locating the criminal, and it has to be for the purpose of extradition or surrender or similar lawful action. This is what Article 82 states. And then the other articles, Article 83 specifies the specific conditions for the publication of a red notice. There are certain limitations and instances where a red notice should not be published. So the instances are mentioned in the rules itself, because the Interpol is governed by a set of rules and a constitution. So everybody has to comply. So if you don't comply with that, then according to Article 36 of the Constitution, people could appeal. So the limitations are mentioned. Red notices may not be published for the following categories of offences. Offences that in various countries raise controversial issues relating to the behavioral or cultural norms. Offences relating to family private matters. Offences originating from a violation of laws or regulations of an administrative nature or deriving from private disputes, unless the criminal activity is aimed at facilitating a serious crime or is suspected of being connected to organized crime. So it goes on. So the limitations are very clearly mentioned. So anybody who would access the rules, this is available in the website. So anyone can access the website and go through these rules. And Article 82, Article 83 is very clear about this. And then for a red notice to be published, there is a penalty threshold also. The penalty threshold with regard to the offence is clearly mentioned. If the person is sought for prosecution, the conduct constituting an offence is punishable by a maximum deprivation of liberty of at least 2 years or more serious penalty. If the person is sought to serve a sentence, she is sentenced to at least 6 months of imprisonment and or there is at least 6 months of the sentence remaining to be served. So it's very clear when one goes through these articles, one can get a clear idea about how the red notice works and what the limitations are and what conditions are. And there are other notices also which are mentioned. Now Article 88 discusses the blue notices. Article 89 discusses the green notices. Article 90, the yellow notices. 91, the black notice. Now, for example, black notice is with regard to dead bodies and dead people. Black notices are published to identify dead bodies. Black notices may only be published under the following conditions, and there are 3 conditions. A black notice may only be published if it provides sufficient identifiers. Sufficient identifiers mean at least a photograph of good quality, fingerprints and DNA profile. So it's very clear. Then 92 discusses the purple notices, Article 93 the orange notices. So what is unique from all these notices, what is unique about the red notice is that a red notice is for the purpose of locating the criminal and it should be used for the purpose of extradition and surrender. So these have to be kept in mind when one deals with a red notice.
Exactly. I want to get into the specific aspect of what you mentioned now. Red notice will directly lead to, its locating purposes and also the extradition aspect also. Before we get to how exactly Interpol deals with the extradition, I want to ask you about the aspect of international crimes that are qualified and what exactly Interpol does as an organization to deal with such, cross-border implication related crimes and also international crimes as a whole. Can you explain to us that aspect, sir?
Interpol deals with international crimes as well as cross-border transnational crimes. International crime is, as you know, Anuradhi, is violation of international law. So crimes like genocide, acts against humanity, war crimes and similar offences are termed as international crimes. Cross-border transnational crime is where part of the offence is committed in one country and the balance is committed in another part, or the crime is committed in one country and it continues and connected to another country. So offences, cross-border transnational offences could be offences like money laundering, human smuggling, drug trafficking and similar offences. So the Interpol deals with both these types of offences, but mainly the NCBs of the relevant countries deal a lot with cross-border transnational crime more than international crime. For international crime, there are other forums also to deal with, like the ICC, the International Criminal Court of Justice, and similar organizations.
So when it comes to the extradition aspect, now we actually had to take a bit of a pause to understand how Interpol deals with international and also cross-border crimes. The extradition aspect now, it's not just red notices. You mentioned there are multiple types of notices. When it comes to Interpol specifically, how does now, once a red notice is issued, there will be, you know, steps taken in order to, once maybe a criminal is located, the extradition aspect has to be looked into. How does Interpol go through that, like specifically when it comes to the legal and diplomatic, you know, the issues that can arise when it comes to handling the scale of such, you know, locating criminals and bringing them back to where the justice will be carried out? How does Interpol work around that specifically?
Yes, as far as the Interpol is concerned, with regard to extradition, the main notice that will be published is the red notice, as we discussed. Because red notice is for the purpose of locating a criminal for the purpose of extradition and surrender and similar activity. So the Interpol also, once the red notice is issued or published, through the I-24/7 communication system, they will communicate with the relevant member states, and they will locate, identify, already the accused is identified, and they will locate the accused. And once the accused is located, the extradition process will commence. Now say a person who's wanted in another country is based in Sri Lanka. So they will first locate through the publication of the red notice. Once the location is done, then it's up to the member states also to get involved formally. So for the purpose of extradition, there will be a formal request sent from the foreign ministry of that particular country to the through the foreign ministry of our country to the Ministry of Defense, because it is the Ministry of Defense that acts upon this extradition request. So the ministry and the minister, if the request is if it qualifies as a legit request, then they will look into the request, and if they feel that steps have to be taken to extradite, they will act under the relevant law. So the relevant law with regard to this is the Extradition Law, Act number 8 of 1977, and which is amended by Act number 48 of 1999. So there section 9 would apply with regard to extradition, where the Minister of Defense will inform the Honorable Attorney General, and the Honorable Attorney General will go before the High Court and seek a warrant of arrest with regard to the wanted criminal. And once the warrant is issued, the warrant will be executed. He will, since he is already located, he will be arrested and brought before the High Court. Of course, the High Court will have an inquiry and see whether it's in order, the request is in order, and if the High Court feels that it is in order, the High Court will make an order for the person to be handed over, and the extradition process will happen accordingly.
Exactly, and that leads me to the next question when it comes to extradition specifically now. Dealing with individuals, or, you know, well, specifically I think it's easier for us to talk about individuals in this context. When it comes to the extradition process, and not just that, when it comes to the functioning of Interpol as a whole, can you tell us about how exactly the rights of individuals that are, you know, sought after through red notices or extradited or even taken action against, especially through the communication channels, how exactly are their rights protected when it comes to Interpol notices? Is there a specific method, a mechanism in order to protect them? Is there an adequate appeal process that we can follow? Can you educate us on that area?
Yes, as I mentioned earlier, the Interpol is governed by the Constitution, the Interpol Constitution and the rules. So as I mentioned, the Interpol's rules on the processing of data has a procedure laid down, and also the Constitution. So any person aggrieved by a decision of the Interpol or a publication of the Interpol and who is dissatisfied can act under, as I mentioned earlier, Article 36. And make a written request to the commission which is called the Commission for the Control of Files. So this is the commission that will look into such request. So internationally, this is the way to handle a problem. So if one has an issue, he can, through his lawyers or on his own, can make a representation on his or her behalf to this commission, and the commission will look into that particular request. So, if I may read Article 36 again, the Commission for the Control of Files is an independent body which shall ensure that the processing of personal information by the organization is in compliance with the regulations the organization establishes in this matter. So, the Commission will see whether the Interpol has complied with the relevant rules and the procedure. And if they have not complied under this article, the Commission is empowered, since it's an independent body, to advise the Interpol to rectify the mistake. So there have been instances where they have rectified, where the red notices have been issued and the red notice had been withdrawn. So you can make representations, and this would be the procedure that a person could act upon under the Constitution, under Article 36. So locally also a person can challenge. Now sometimes the police, before getting a red notice, might go before the magistrate's court and seek a warrant, or might go before the High Court and seek a warrant. Even with regard to extradition, there will be an application made under Section 9 of the extradition law. In instances like that, any person who is aggrieved by such action can go before those courts and make an application on his or her behalf. And otherwise, it can be challenged by revision application. The orders can be challenged by revision applications, or one could file a writ in the Court of Appeal and challenge the magistrate's order. So similar actions are available. But as far as the Interpol Constitution is concerned, it is Article 36 that one would have to act upon.
So moving forward, sir, I do want to talk about, Sri Lanka's judiciary and its role when it comes to interacting with Interpol. We have come to time on this segment, so we'll have to get into those specifics right after this. Let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment.
Question is on future developments. How can we expect that Sri Lanka's relationships with Interpol to change over the years to come?
Welcome back to Law, Land and Liberty. We're in our final segment with Mr. Lakmal Ratnayake, attorney at law. Unfortunately, we are in our final segment and we're running out of time a little bit. But I think this is an important question that before we end off, I have to ask you. So relating to how our judiciary is going to be interacting with Interpol, how exactly does that dynamic occur, especially when it comes to, cases that are occurring in Sri Lanka? Now, we don't know any specifics, but what role does the judiciary, apart from, actually carrying out, arrest warrants, maybe international arrest warrants, when it comes to Interpol's context, how does our judiciary handle that connection?
Well, with regard to red notices, there is minimal judicial involvement because it is a notice that is being published in the Interpol system. So the judiciary will not get directly involved in that process, but however, there will be instances where the local police departments will file applications seeking warrants from our courts of law. In situations like that, the judiciary in Sri Lanka will get involved in such matters where they have to issue an order with regard to an arrest warrant. So sometimes these arrest warrants are used by the police, misused by the police to obtain red notices against some suspects also. Now, in my view, Anuradhi, these red notices should be issued with regard to accused and convicts, because according to, as I told you earlier, the red notices are issued for the purpose mainly of extradition and surrender. So the extradition law, the preamble to the extradition law talks about mainly accused and convicts. and not suspects. So my thinking is that this should not be applicable to suspects, because it clearly states to regulate the treatment of persons accused or convicted of offences in Sri Lanka. So it does not talk about suspects. So when it comes to extradition and red notices, it should be only with regard to suspects. But what I see is, I have seen enough examples in Sri Lanka where applications have been made before courts of law with regard to suspects. And the applications had been to seek a warrant with regard to the suspect, even with regard to sometimes cognizable offences where a warrant is not required, as you are aware, to make an arrest. The police would still go before a court and seek a warrant. And the police will also sometimes misrepresent facts and say that this person cannot be found and a warrant may be issued. And then the judicial officers have to also be very cautious in issuing these warrants, because sometimes the police make use of that warrant, and through the NCB, the National Central Bureau, they will, because the Interpol will not have the details of the warrant, they will use that warrant against the suspect to sometimes obtain a red notice with regard to a suspect. So, as I told you, the red notice should be for the purpose of extradition or surrender, and the extradition law says that it is applicable to accused and not suspects, accused and convicts. So, to become an accused, you have to have a charge sheet filed against you or plain filed against you in a magistrate's court, or you have to be indicted in a court of law. And to become a convict, it should happen after trial or after a plea of guilt. So without that, for the purpose of investigation, it is wrong to misrepresent and try to obtain a red notice. So the judiciary has to be cautious in issuing these types of warrants. And also the judiciary will also get involved, because if there is an extradition process, that process under section 9 of the extradition law, the application has to be made before a high court for the warrant. So if one is seeking a warrant to arrest a located person, they will have to make that application, the state will have to make that application before an honorable high court judge. So in a situation like that, the judiciary will have to get involved. Other than that, the judicial involvement is minimal in this type of activity. So I feel yes.
Yes, so that means we have to see, when it comes to the nuances of issuing a red notice in itself, also there is the entire issue with extradition, specifically when it comes to our context also. But there's this question that arises when it comes to cooperating with international organizations like Interpol, specifically considering our geolocation and also our geopolitical situation. It's an important question that arises in our head, how we should be moving forward as a nation when we are interacting with bodies like Interpol. What can we expect, especially for a country like Sri Lanka, in order to strengthen and better have cooperation with organizations like these, especially when it comes to dealing with cross-border international crimes? What can we expect moving forward, and how do you think we should go about this?
Yeah, it's a good question, Anuradhi, because this is an area that Sri Lanka should look at very seriously, because the public is not very aware, and even some of our officials are not properly trained to handle with these international affairs and international crime and international matters. So I think we need more training, more knowledge, more information, capacity building to develop this area. And we need more dialogue also, because this is not an area that is being discussed. So it's up to the authorities to hold discussions, have seminars, and educate the public and also the officials about the rights, the procedures, the rules as to how this could be developed. And also in other countries, you get Interpol experts. And to my knowledge, I don't think we have that many experts in Sri Lanka with regard to this type of issues and matters. So this is something that the government and the authorities should look at. and also the international agencies also, because now we are a signatory to the United Nations Convention against transnational organized crime and the protocols there too. So we can work with the United Nations also with regard to these issues, and also we can work with the Interpol. They will have the expertise to do training, and there have been instances where our officers have received training from the Interpol. So this is an area that we should look at for the future, and this is an area where more discussion should happen, more training should be done, and the community should be educated on.
Exactly, and thankfully, hopefully, this discussion can also lend towards that open discussion, and our viewers have probably definitely walked away with a better understanding of what Interpol is and how exactly it's relevant in our context specifically. Thank you very much, sir. Unfortunately, our time today has run out, even though we did have a few more areas that we wanted to dive into. Maybe in a future program, we can actually discuss more on the nuances and specifics. But Mr. Lakmal Ratnayake, attorney at law, thank you very much, sir, for coming down to the studio today and explaining this area to us.
Thank you.
All right, well, we'll leave you tonight with the words of United States Senator Mark Hatfield. Unless we have a well-educated people, we're vulnerable on our national security. If you missed any of today's programs, you can always rewatch on youtube.com/othertharenenglish, and please do share your thoughts and feedback with us through email at feedback.8024english@derana.lk or via WhatsApp at 076 805 7933. Thank you very much for watching. Have a good night.